Hi friend, welcome to the company law update. Today we are discussing Madhya Pradesh ROC adjudication order dated uh, 6th December 2023 for the non-appointment of the CFO. That is the violation of section 203 subsection 1 of the Companies Act. Let's see the facts of the case. Company name is Silf Technologies Limited, having a register office at Indore, Madhya Pradesh. And about facts of the case, that an inquiry under section 206 subsection 4 is conducted by the officer. The directorate by its direction dated 1st May 2023 has directed ROC Gwalior to take necessary action in the matter for the violation of section 203 subsection 1 of the Companies Act. During inquiry, the company has no CFO appointed since 2015-16 to 2018-19, and thus it appears that the company has violated the provision of section 203 subsection 1 of the Companies Act, which attracted penal provision of section 203 subsection 5 of the Companies Act for the period from 2nd November 2018 to 31st March 2019. Subsequently, the office has issued so-called notice to the company and its officer in default. Uh, in response to this office so-called notice, this office has received a letter from one of the director. Therein, he had informed that he has resigned from the directorship of the company in March 2022. He has also informed that 30 days time to respond of the notice is required. One another letter also received from the uh, two director, and both have informed that they had also resigned for the directorship of the company in March 2022 and also requested to grant 30 days time for responding time to so-called notice. A letter is also received from the same director that uh, he had informed that one of the director has expired in April 2021. A certificate in this regard is also includes and had requested to drop the proceeding against the expired director. Thereafter, notice of inquiry were issued to the company and its officer in default. In response to the aforesaid notice, this office has received a mail from the to director and inform on the following point that notices are in the violation of section 203 subsection 1 of the Companies Act for non-appointment of the CFO during the period 2nd November 2018 to 31st March 2019, whole-time director during the period 2nd November 2018 to 31st March 2019, and company secretary during the period 2nd November 2018 to 30th May 2019, and that we have applied for the compounding of offense with authority for filing by filing requisite form, and that we were not executing the non-executive director of the company during the period of violation as mentioned in your notice, and were not looking for the day-to-day affairs of the company. We were not looking for the day-to-day affairs of the company, and we inform you that we have tried our level best to appoint the eligible person to the company, but we could not find eligible person and who could have accepted the appointment in the company, looking financial state position and business of the company. And default by the company was not on account of our fault, but because the circumstances in the market and financial situation of market and company, and due to our continuous effort, we could find the eligible person and appointed them, and that we have not drawn any remuneration, not nor sitting fee for the board meeting in the entire duration of our directorship. meaning thereby we have not gained any money from the company, and it is not out of place to mention that since the company financial position was not good, and this director as director have given interest free loan to the company to make company fill its financial obligation, and requested to condone the violation of section 203 of the companies act. This was not intentional, and they have also informed that they have resigned from the directors of the company in month of the March 2022. And in response to the aforesaid notices, this office has also received a mail from one of the director, and informing the following fine that notices are in the violation of 203 of the Companies Act for non-appointment of CFO for the aforesaid period, and whole-time director and company secretary for the said period, and that he has applied for compounding of officer of offense with the authority by filing requisite form for the office before 2nd November 2018, and he was non-executive independent director of the company during the period of violation, and this is informed here. And as per the education company education penalty rules, and the date of the hearing was fixed on 5th December 2023, and in the office of the ROC, Madhya Pradesh. On hearing date, no person of the company or representative of the director has attended the hearing, and therefore the order, having considered the facts and circumstances of case, and after taking into account the factors above and later issued by the ROC Gwalior, it is concluded that the company and its officer in default are liable for penalty as prescribed under section 203 subsection 5 of the Act for default in made in complying with the requirement of section 201 of the Companies Act. And on the company, that is there is 210 days delays in terms of section 203 subsection 1 of the Companies Act. Accordingly, ROC imposed penalty as below, that for non-appointment of CFO, that on the company there delay a number of days of default 210 days. This is the total penalty as a 5 lakh on the company, and 1,000 per day, that is a total 7 lakh 10,000, and maximum penalty subject to ceiling 5 lakh, so that maximum penalty 5 lakh imposed on the company. And three director, there is three director, and on that three director there is the maximum penalty 50,000 plus 1,000 per day for 210 days is 2,60,000, subject to maximum of the penalty 5 lakh. So here penalty calculated as 2,60,000 on each on the three director, and in the opinion that the penalty is commensurate with the aforesaid failure committed by the notice, and penalty so imposed upon the officer in default shall be paid from their personal source or income. Here on the director, they shall be paid there from the personal source or income, and it is further directed that the penalty imposed shall be paid to the MCA portal only, as mentioned in Rule 3 sub Rule 14 of the Company Education Penalty Rules 2019 under intervention to this office. And if preparing appeal, then file appeal within 60 days from the date of the order, and any person aggrieved by the order of the education authority may prefer an appeal to regional director having jurisdiction in the matter, and every appeal shall be filed within 60 days from the date on which the copy of order of this education authority is received by the aggrieved person. And in case of the default and company fails to comply with the order, and then within the 90 days from the date of the receipt of a copy of the order, the company shall be punishable with a fine which shall not be less than 25,000, but which may extend to 5 lakh rupees. And for the officer of the company, if in case of the failure, that is the within the 90 days from the receipt of this order, such officer shall be punishable with the imprisonment which may extend to 6 months, or with fine which not less than the 25,000 rupees, but which may extend to 1 lakh rupees, or both. This is the education order copy, and this education order copy is the pronounced on the 5th December 2023. In case of any inquiry, you may uh, give your comments in the comments box, and you if you need education order copy, then please message on my WhatsApp number. Thank you so much for watching this update.